A jury trial. A trial by jury is a legal proceeding in which a jury either makes a decision or makes findings of fact, which then direct the actions of a judge. It is distinguished from a bench trial, in which a judge or panel of judges makes all decisions. Jury trials are used in a significant share of serious criminal cases in almost all common law legal systems, and juries or lay judges have been incorporated into the legal systems of many civil law countries for criminal cases. Only the United States makes routine use of jury trials in a wide variety of non-criminal cases. Other common law legal jurisdictions use jury trials only in a very select class of cases that make up a tiny share of the overall civil docket, while true civil jury trials are almost entirely absent elsewhere in the world. Some civil law jurisdictions do, however, have arbitration panels where non-legally trained members decide cases in select subject matter areas relevant to the arbitration panel members' areas of expertise. The availability of a trial by jury in American jurisdictions varies, because the United States legal system separated from that of the English at the time of the American Revolution. The types of proceedings that use juries depends on whether such cases were tried by jury under English common law at the time, rather than the methods used in English or UK courts in the present. For example, at the time English courts of law tried cases of torts or private law for monetary damages, but courts of equity tried civil cases seeking an injunction or another form of non-monetary relief. As a result, this practice continues in American civil laws, even though in modern English law only criminal proceedings and some inquests are likely to be heard by a jury. The use of jury trials evolved within common law systems rather than civil law systems, has had a profound impact on the nature of American civil procedure and criminal procedure rules. Even in cases where a bench trial is actually contemplated in a particular case, in general, the availability of a jury trial, if properly demanded, has given rise to a system where fact-finding is concentrated in a single trial rather than multiple hearings, and where appellate review of trial court decisions is greatly limited. Jury trials are of far less importance in countries that do not have a common law system. History. Greece. Ancient Athens had a mechanism called dikaste to assure that no one could select jurors for their own trial. For normal cases, the courts were made up of dikaste of up to 500 citizens. For capital cases, those that involved death, loss of liberty, exile, loss of civil rights, or seizure of property, the trial was before a jury of 1,001 to 1,501 dikaste. In such large juries, the unanimity rule would be unrealistic and verdicts were reached by majority. Juries were appointed by lot. Jurors cast a ceramic disc with an axle in its middle. The axle was either hollow or solid. Thus the way they voted was kept secret because the jurists would hold their disc by the axle by thumb and forefinger, thus hiding whether its axle was hollow or solid. Since Periclean times, jurists were compensated for the sitting in court with the amount of one day's wages. The institution of trial by jury was richly depicted by Aeschylus in the Eumenides, the third and final play of his Orestia trilogy. In this play, the innovation is brought about by the goddess Athena, who summons 12 citizens to sit as jury. The god Apollo takes part in the trial as the advocate for the defendant Orestes, and the Furies as prosecutors for the slain Clytemnestra. In the event the jury is split 6-6, and Athena dictates that in such a case the verdict should henceforth be for acquittal. Rome. For the beginning of the Republic and in the majority of civil cases towards the end of the Empire, there were tribunals with the characteristics of the jury, the Roman judges being civilian, lay and not professional. Capital trials were held in front of juries composed of hundreds of thousands of people in the commissures of centuries, the same as in Roman trials. Roman law provided for the yearly selection of judices, who would be responsible for resolving disputes by acting as jurors, with a praetor performing many of the duties of a judge. High government officials and the relatives were barred from acting as judices, due to conflicts of interest. Those previously found guilty of serious crimes were also barred, as were gladiators for hire, who likely were hired to resolve disputes through trial by combat. The law was as follows. The peregrine praetor within the next 10 days after this law is passed by the people or plebs shall provide for the selection of 450 persons in this state who have had a night census, provided that he does not select a person who is a has-been plebeian tribune, quaestor, triumvir capitalize, military tribune in any of the first 4 legions, or triumvir for granting and assigning lands, or who is a has-been in the Senate, or who has fought or shall fight as a gladiator for hire, or who has been condemned by the judicial process under public trial whereby he cannot be enrolled in the Senate, or who is less than 30 or more than 60 years of age, or who does not have his residence in the city of Rome or within 1 mile of it, or who is the father, brother, or son of any above described magistrate, or who is the father, brother, or son of a person who is or has been a member of the Senate, or who is overseas. Holy Roman Empire. A Swabian ordinance of 1562 called for the summons of jurymen, and various methods were in use in Emmending and Oppenau and Oberkirch. Hohenstein's Charter of 1442 secured the right to be tried in all cases by 24 fellow equals, and in Freiburg the jury was composed of 30 citizens and councillors. The modern jury trial was first introduced in the Rhenish provinces in 1798, with a court consisting most commonly of 12 citizens. The system whereby citizens were tried by the peers chosen from the entire community in open court was gradually superseded by an engine of tyranny and oppression in Germany, in which the process of investigation was secret and life and liberty depended upon judges appointed by the state. In Constance the jury trial was suppressed by decree of the Habsburg monarchy in 1786. The Frankfurt Constitution of the failed revolutions of 1848 called for jury trials for the more serious crimes and all political offences, but was never implemented after the Frankfurt Parliament was dissolved by Württemberg dragoons. An 1873 draft on criminal procedure produced by the Prussian Ministry of Justice proposed to abolish the jury and replace it with a mixed system, causing a significant political debate. In the Weimar Republic the jury was abolished by the Eminger Reform of 4 January 1924. Between 1948 and 1950 in American-occupied Germany and the Federal Republic of Germany, Bavaria returned to the jury trial as it had existed before the emergency decrees, but they were again abolished by the 1950 Unification Act for the Federal Republic. In 1979, the United States tried the East German lot Flight 165 hijacking suspects in the United States Court for Berlin in West Berlin, which declared the defendants had the right to a jury trial under the United States Constitution, and hence were tried by a West German jury. England and Wales. According to George Macaulay Trevelyan in A Shortened History of England, during the Viking occupation, The Scandinavians, when not on the Viking warpath, were a litigious people and loved to get together in the thing to hear legal argument. They had no professional lawyers, but many of the farmer warriors, like Njal, the truth-teller, were learned in folk custom and in its intricate judicial procedure. A Danish town in England often had, as its main offices, 12 hereditary lawmen. The Danes introduced the habit of making committees among the free men in court, which perhaps made England favourable ground for the future growth of the jury system out of a Frankish custom later introduced by the Normans. The English king Ethelred the Unready set up an early legal system through the Wantage Code of Ethelred, one provision of which stated that the 12 leading thegns of each wapentake were required to swear that they would investigate crimes without a bias. These juries differed from the modern sort by being self-informing. Instead of getting information through a trial, the jurors were required to investigate the case themselves. In the 12th century, Henry II took a major step in developing the jury system. Henry II set up a system to resolve land disputes using juries. A jury of 12 free men were assigned to arbitrate in these disputes. As with the Saxon system, these men were charged with uncovering the facts of the case on their own rather than listening to arguments in court. Henry II also introduced what is now known as the grand jury through his Assize of Clarendon. Under the Assize, a jury of free men was charged with reporting any crimes that they knew of in the hundred to a justice in eyre, a judge who moved between hundreds on a circuit. A criminal accused by this jury was given a trial by ordeal. The Church banned participation of clergy in trial by ordeal in 1215. Without the legitimacy of religion, trial by ordeal collapsed. The juries under the Assizes began deciding guilt as well as providing accusations. The same year, trial by jury became an explicit right in one of the most influential clauses of Magna Carta. Article 39 of the Magna Carta reads, Nullus libor homo capiatur velum praesetur, aut desicetur de libero tenimento, vel libertatibus, vel liberis consuetudinibus sui, sut utligatur, aut exolatur, aut aliquo modo destruitur, nec super eum ibumus, nec super eum mitamus, nisi per legally judicium imperium suorum, vel per legem terra. It is translated thus by Lysander Spooner in his essay on the trial by jury. No free man shall be captured, and or imprisoned, or disseised of his freehold, and or of his liberties, or of his free customs, or be outlawed, or exiled, or in any way destroyed, nor will we proceed against him by force or proceed against him by arms, but by the lawful judgment of his peers, and by the law of the land. Quote, although it says and by the law of the land, this in no manner can be interpreted as if it were enough to have a positive law, made by the king, to be able to proceed legally against a citizen. The law of the land was the consuetudinary law, based on the customs and consent of John's subjects, and since they did not have parliament in those times, this meant that neither the king nor the barons could make a law without the consent of the people. According to some sources, in the time of Edward III, by the law of the land had been substituted by due process of law, which in those times was a trial by 12 peers. The Magna Carta of 1215 further secured trial by jury by stating that for a trivial offence, a free man shall be fined only in proportion to the degree of his offence, and for a serious offence correspondingly, but not so heavily as to deprive him of his livelihood. In the same way, a merchant shall be spared his merchandise, and a husbandman the implements of his husbandry, if they fall upon the mercy of a royal court. None of these fines shall be imposed except by the assessment on oath of reputable men of the neighborhood. Earls and barons shall be fined only by their equals, and in proportion to the gravity of their offense. To any man whom we have deprived are dispossessed of lands, castles, liberties, or rights, without the lawful judgment of his equals, we will at once restore these. If we have deprived or dispossessed any Welshman of lands, liberties, or anything else in England or in Wales, without the lawful judgment of their equals, these are at once to be returned to them. A dispute on this point shall be determined in the marches by the judgment of equals. English law shall apply to holdings of land in England, Welsh law to those in Wales, and a law of the marches to those in the marches. The Welsh shall treat us and ours in the same way. During the mid-14th century, persons who had sat on the presenting jury were forbidden to sit on the trial jury for that crime. 25 Edward III Stat. 5, c. 3. Medieval juries were self-informing, in that individuals were chosen as jurors because they either knew the parties and the facts, or they had the duty to discover them. This spared the government the cost of fact-finding. Over time, English juries became less self-informing and relied more on the trial itself for information on the case. Jurors remained free to investigate cases on their own until the 17th century, the Magna Carta being forgotten after a succession of benevolent reigns. The kings, through the royal judges, began to extend the control over the jury and the kingdom. In David Hume's History of England, he tells something of the powers that the kings had accumulated in the times after the Magna Carta, the prerogatives of the crown and the sources of great power with which these monarchs counted. One of the most ancient and most established instruments of power was the Court of Star Chamber, which possessed an unlimited discretionary authority of fining, imprisoning, and inflicting corporal punishment, and whose jurisdiction extended to all sorts of offences, contempts, and disorders that lay not within reach of the common law. The members of this court consisted of the Privy Council and the judges, men who all of them enjoyed their offices during pleasure, and when the prince himself was present, he was the sole judge, and all the others could only interpose with their advice. There needed but this one court in any government to put an end to all regular, legal, and exact plans of liberty. Who durst set himself in opposition to the crown and ministry, or aspire to the character of being a patron of freedom, while exposed to so arbitrary a jurisdiction? I much question whether any of the absolute monarchies in Europe contain, at present, so illegal and despotic a tribunal. While so many terrors hung over the people, no jury durst have acquitted a man when the court was resolved to have him condemned. The practice also of not confronting witnesses to the prisoner gave the crown lawyers all imaginable advantage against him, and, indeed, there scarcely occurs an instance, during all these reigns, that the sovereign, or the ministers, were ever disappointed in the issue of a prosecution. Timid juries, and judges who held their offices during pleasure, never failed to second all the views of the crown, and as the practice was anciently common of fining, imprisoning, or otherwise punishing the juries, merely at the discretion of the court, for finding a verdict contrary to the direction of these dependent judges, it is obvious that juries were then no manner of security to the liberty of the subject. The first paragraph of the Act that abolished the Star Chamber repeats the clause on the right of a citizen to be judged by his peers. Abolition of the Star Chamber. July 5, 1641, and Act for the regulating of the Privy Council, and for taking away the court commonly called the Star Chamber. Whereas by the Great Charter many times confirmed in Parliament, it is enacted that no freeman shall be taken or imprisoned, or disseised of his freeholder liberties, or free customs, or be outlawed or exiled or otherwise destroyed, and that the king will not pass upon him, or condemn him, but by lawful judgment of his peers, or by the law of the land. In 1672, Quakers charged with unlawful assembly, William Penn and William Meade, were found not guilty by a jury. The judge then fined the jury for contempt of court for returning a verdict contrary to their own findings of fact and removed them to prison until the fine was paid. Edward Bushell, a member of the jury, nonetheless refused to pay the fine. Bushell petitioned the Court of Common Pleas for a writ of habeas corpus. The ruling in the Bushell's case was that a jury could not be punished simply on account of the verdict it returned. Many British colonies, including the United States, adopted the English common law system in which trial by jury is an important part. Jury trials in criminal cases were a protected right in the original United States Constitution, and the 5th, 6th, and 7th Amendments of the U.S. Constitution extend the rights to trial by jury to include the right to jury trial for both criminal and civil matters and a grand jury for serious cases. The role of jury trials. In most common law jurisdictions, the jury is responsible for finding the facts of the case, while the judge determines the law. These peers of the accused are responsible for listening to a dispute, evaluating the evidence presented, deciding on the facts, and making a decision in accordance with the rules of law and the jury instructions. Typically, the jury only judges guilt or a verdict of not guilty, but the actual penalty is set by the judge. An interesting innovation was introduced in Russia in the judicial reform of Alexander II. Unlike in modern jury trials, jurors decided not only whether the defendant was guilty or not guilty, but they had the third choice: guilty, but not to be punished, since Alexander II believed that justice without morality was wrong. In France and some countries organized in the same fashion, the jury and several professional judges sit together to determine guilt first. Then, if guilt is determined, they decide the appropriate penalty. Some jurisdictions with jury trials allow the defendant to waive the right to a jury trial, thus leading to a bench trial. Jury trials tend to occur only when a crime is considered serious. In some jurisdictions, such as France and Brazil, jury trials are reserved and compulsory for the most severe crimes and are not available for civil cases. In Brazil, for example, trials by jury are applied in cases of voluntary crimes against life, such as first and second-degree murder, forced abortion and instigation of suicide, even if only attempted. In others, such as the United Kingdom, jury trials are only available for criminal cases and very specific civil cases. In the United States, jury trials are available in both civil and criminal cases. In Canada, an individual charged with an indictable offense may elect to be tried by a judge alone in a provincial court, by judge alone in a superior court, or by judge and jury in a superior court. Summary offenses cannot be tried by jury. In the United States, because jury trials tend to be high-profile, the general public tends to overestimate the frequency of jury trials. Approximately 150,000 jury trials are conducted in state courts annually, and an additional 5,000 jury trials are conducted in federal courts. Two-thirds of jury trials are criminal trials, while one-third are civil and other. Nevertheless, the vast majority of criminal cases are settled by plea bargain, which removes the need for a jury trial. Some commentators contend that the guilty plea system unfairly coerces defendants into relinquishing the right to a jury trial. Others contend that there never was a golden age of jury trials, but rather that juries in the early 19th century were unwitting and reflexive, generally wasteful of public resources and, because of the absence of trained professionals, little more than slow guilty pleas themselves, and that the guilty plea system that emerged in the latter half of the 19th century was a superior, more cost-effective method of achieving fair outcomes. Pros and cons. In countries where jury trials are common, juries are often seen as an important check against state power. Other common assertions about the benefits of trial by jury is that it provides a means of interjecting community norms and values into judicial proceedings, and that it legitimizes the law by providing opportunities for citizens to validate criminal statutes in their application to specific trials. Alexis de Tocqueville also claimed that jury trials educate citizens about self-government. Many also believe that a jury is likely to provide a more sympathetic hearing, or a fairer one, to a party who is not part of the government or other establishment interest than would representatives of the state. This last point may be disputed. For example, in highly emotional cases, such as child rape, the jury may be tempted to convict based on personal feelings rather than on conviction beyond reasonable doubt. In France, a former attorney, then later Minister of Justice Robert Badinter, remarked about jury trials in France that they were like riding a ship into a storm, because they are much less predictable than bench trials. Another issue with jury trials is the potential for jurors to be swayed by prejudice, including racial considerations. An infamous case was the 1992 trial in the Rodney King case in California, in which white police officers were acquitted of excessive force in the violent beating of a black man by a jury consisting mostly of whites, without any black jurors. The positive belief about jury trials in the UK and the US contrasts with popular belief in many other nations, in which it is considered bizarre and risky for a person's fate to be put into the hands of untrained laymen. Consider Japan, for instance, which used to have optional jury trials for capital or other serious crimes between 1928 and 1943. The defendant could freely choose whether to have a jury trial by judges, and the decisions of the jury were non-binding. During the Tojo regime this was suspended, arguably stemming from the popular belief that any defendant who risks his fate on the opinions of untrained laymen is almost certainly guilty. Similarly, jury trials were abolished by the government of India in 1960 on the grounds that they would be susceptible to media and public influence. One Pakistani judge called the trial by jury amateur justice. Malaysia abolished its jury system on the 1st of January 1995, citing inter alia the danger of jurors untrained in the legal profession delivering verdicts colored by emotions or popular perception. One of the last trials by jury in Malaysia was the notorious Mona Fandey case in 1994. Jury trials in multicultural countries with a history of ethnic tensions may be problematic, and lead to juries being unduly biased and partial. This is one of the reasons why both India and Pakistan abolished jury trials soon after independence. Indeed, in these countries, a jury trial is seen as a failing of some foreign legal system rather than an advantage. This is despite the fact that both nations are common law countries. A major issue in jury trials is the secretive nature of the process. While proponents may say that secrecy allows the jury to remain impartial by protecting it from undue pressure or attention, opponents contend that this prevents them from being a transparent trial. The fact that juries do not often have to give a reason for the verdict is also criticized, since opponents argue it is unfair for a person to be deprived of life, liberty or property without being told why it is being done so. In contrast, where there is a decision by a judge or judges, they are required to provide often detailed reasons of both fact and law as to why the decision was made. One issue that has been raised is the ability of a jury to fully understand statistical or scientific evidence. It has been said that the expectation of jury members as to the explanatory power of scientific evidence has been raised by television in what is known known as the CSI effect. In at least one English trial, the misuse, a misunderstanding, a misrepresentation by the prosecution of statistics has led to wrongful conviction.